On the morning drive, this is Mirror Business FM, and it's legal matters next. This time breaking down the latest legal requirements for employers when it comes to terminating employees here in the UAE. And more, especially during probation, changes in the UAE labour law, plenty of questions coming from both HR professionals and employees, workers. So it's kind of essential to understand your rights and your obligations. Joining us to get to the heart of this about what employers have to do to stay compliant and what employees can expect as well if they face termination. Legal expert Raymond Kisswany is here. He's a partner at Davidson and Co. Nice to see you.
Nice, man.
Always good to have you here.
Always a pleasure.
So let's get to the bottom of this. Very important for all of us, but I guess it's only fair that we take the employer and the employee perspective. So we'll try and be as balanced as we can. But Raymond, let's start, if you don't mind, briefly explain what the UAE labour law says about terminating an employee, particularly given that you are able to do that during the probation period, aren't you? That's possible.
Yeah, exactly. So under UAE employment law, labor law, termination is permitted, but it has to follow kind of very clear and specific statutory rules around things like notice, the process, and the final settlement.
Yeah.
In simple terms, there's effectively two main routes. There's termination with notice. That's the quote-unquote standard route. And there's termination without notice. And that is only in very specific, very serious cases. And there's very strict requirements on when you can do that. Probation is where employers often get complacent. But probation is not a legal quote-unquote free zone. The law allows termination during probation, but it still requires minimum written notice and a very clear documented exit for the employee. So practically the biggest message, I think, is for employers is even if the employee is new, so they're falling into that probationary period, you still need to treat termination like a formal legal step and a process, not just an informal HR conversation.
So it's not as though, somebody joins you and they're on a 2-week or whatever the probation period might be. It's not like, we're just testing you out. We can throw you to once. It's not that at all, is it?
Yeah, exactly. Like there's been a number of employers that have sort of thought the probationary period is kind of, I hire this person, I kind of test them out. You know, I don't have to go through. I mean, there was one instance where they were not even issuing visas for employees during the probationary period until they passed the probationary period. That is really just a clear no-no. You hire someone, you treat them immediately as an employee. That probationary period only really just reduces the notice period, the effect of that around it. But it doesn't sort of, probation isn't this kind of magic wand where an employer can just walk up to an employee and say, it's not working out, see you later.
Yeah, it's not, you're fired.
Yeah, it's not also, The Apprentice.
No, it isn't like that. It's not a TV show, this. But that's interesting. So if you start a role, you're in a probation period, and your employer is holding back with the standard visa, the work permit, etc., not only is that a red flag, that's also illegal, isn't it?
100 million %. Yeah.
Yeah. Okay.
And there's been some seriously horror stories, because we at Davidson's have acted on both sides of this, for employers and for employees. And there's some real horror stories where people don't get their visas, don't get any of the benefits or the issues that an employee should be getting until they have quote unquote passed that probationary period. And that's just it's not only a red flag for the employee, but as you absolutely put it, it is 100% against the law.
Okay, so double red flag, if you like, I suppose.
Absolutely.
Right. So according to the latest rulings or the changes in the law or the additions to the law, amendments, I'm not sure quite how that applies, but what's the notice period that employers have to give if you need to terminate somebody on probation? It's just not working. Is there a minimum notice period?
Yeah. So the key rule is very straightforward. It's during probation, the employer must give the employee at least 14 days written notice before termination takes effect. And and written, I kind of specified that because it does matter. It's not a conversation. It's not a, hey, this isn't working out, you're fired sort of thing. It has to be in writing. In good practice, in good order, this has to be some form of a dated letter or an email that confirms the decision to terminate during probation, when the notice period starts, when the final working day is, and what happens during this notice period, during these at least 14 days in terms of handover, access, workplace attendance, etc. Again, where employers get caught in the wrong here is by giving no notice or giving a verbal notice or kind of giving a notice but leaving days vague about when it started, when's the last leaving day, etc. And that's really when disputes arise.
Okay, so that's with notice. What about situations where an employer can terminate without notice? And you pointed to the with and without a while ago. Is that I don't like the cut of your jib, you're wearing poor shoes, I don't like you. Yeah. That's obviously a much more serious matter in terms of there's an infraction in some way, I guess.
Yeah. Yeah. So, I can't stress this enough because this is literally the highest risk for employers, because termination without risk is only permitted in very specific legal grounds.
Okay.
Because it is very serious, because you're effectively terminating somebody without any form of notice. You're literally coming up to them and saying, you're done, and that's it.
Right.
And this is where an employer has to prove effectively two things. One, that the facts fall within one of the recognized quote-unquote serious misconduct categories, and that the employer followed a proper investigation and documentation process before the termination existed. We often call this summary dismissal. It's not meant for any sort of poor performance, personality clashes, or it's just not working out, whether it's during probation or not during probation. It's intended for very serious situations, things like fraud, assault, serious breach of safety, unauthorized access, things that effectively give rise to either criminal or civil claims that an employer can take against the employee.
Okay.
That's the kind of seriousness that it has to take. It's a lot of employers think they often have those grounds, but I would always caution that you fall on the side of not doing this unless there is very, very, very good reason to do it. And if you think that there is, follow that process of conducting an investigation and documenting it well.
And the point there is follow the process, provide the documentation, and you need to have the proof.
Absolutely.
For this to be, were it taken.
Yeah,
first.
exactly. Even if you have the slightest kind of unsure if this is if it falls within one of those parameters, because what a non-lawyer thinks is fraud, or what a lawyer thinks is serious misconduct, is not usually what is the legal standard there. So definitely either have a dedicated HR team that knows the rules inside out and discuss that with them, or seek legal advice before you do one of these, because this is where if you don't have your ducks in a row, it's going to get challenged, and it's not going to be a good outcome.
Okay. Let's talk about documents and, I guess, payments that need to be made. What do you have to provide if you terminate an employee, even if it is during the probationary period?
Yeah, so even during probation, you still have to think about it in kind of a few different areas. You have to think about the final payments, the documents, and the immigration/admin steps. So in terms of final pay, you have to pay the salary up to the last working day. Any sort of accrued contractual entitlements that have become payable, those need to be settled. So, for example, if the employee has accrued any leave, for example, and where it's relevant, I think it's always helpful to give a final settlement breakdown in terms of some form of a a breakdown in terms of what that settlement is, because that always helps both parties be on an equal footing when that final day comes. In terms of documentation, again, the written termination notice, an experience certificate where the employee requests it, and they usually should do, and any sort of standard guidance that you have internally in terms of HR clearance documents, the handover confirmation, a checklist that the employee has handed all company items, for example, a company phone or a laptop, etc. So just making sure that by that final day, both parties understand that everything's been paid, that has been owed, everything has been returned that should have been returned, because that will literally prevent about 99% of disputes.
Okay, so with this, termination letter, that should be physically offered, or how do you terminate somebody? Can it be WhatsApp, email? How?
Well, I mean, anything technically falls
Anything that can be documented,
as in writing. So it technically doesn't have to be a physical letter that you print out and sort of you hand over. It can be an email. It just has to be a form of writing that clearly states, one, the decision to terminate, whether that termination, if it's happening during a probationary period, that termination is happening during that period.
Yeah.
Clearly dated as to when the termination has happened, clearly documenting when the last working day is, and what is to be expected during that notice period.
Does there need to be a reason offered for termination?
Not necessarily, no. I mean, it's only that you have to have if you are conducting a summary dismissal, i.e. the termination without notice, that you need to have it internally there as to what is happening, what you have investigated, and what is the outcome of that investigation that led to the termination without notice.
Right, okay.
But I mean, effectively, it is what we call an employment at will. So it's just not working out. Either side usually has the right to simply give notice to the other, and as long as it falls within the contractual notice period, that's fine. There doesn't have to be a specific reason for it.
I mean, as long as you're working within the confines of the law, it's a very one-sided thing. There's no expectation that if you terminate somebody and you notify them and everything's in order, there's no response necessary. There's, if you're given a termination letter, you're fired and this is why. I'm like, oh, okay, I don't need to sign that. There's no reasonable expectation that an employee has to accept that. The fact is, it has happened.
Yeah,
do you know what I mean?
Yeah, it's not like like those movies where you have to kind of put two keys in to launch the nuclear submarine sort of thing. The employee doesn't have to necessarily agree with the fact that he or she is being terminated. It is just a matter of fact that the law allows that you can terminate someone for no reason, either that it's just not working out, whatever that reason is, and you don't have to disclose that reason. It's just, this is a decision that's been taken by management, the employer, and we are following the notice period.
I mean, I say that because, in my head, I can think of a couple of instances where that has happened in the course of my career. Not to me, fortunately, but I've seen it, and it's been, well, you can't do that. No, and it's almost a lack of acceptance on the part of the employee. Yeah. But the simple fact is, that's not the case.
No.
If you're within, right, no, okay.
As long as you're following the process.
As long as you're following the process, yeah, absolutely right. You mentioned something there that I think is important to bring up here, and this is the experience certificate, which I guess is an important thing. It's an entitlement, isn't it? That it's something that you should offer, that an employee or an ex-employee, I suppose in this case, has the right to ask for. What should be in the experience certificate?
Yeah. So this one often gets very confused by employers as to what they have to do, what they don't have to do. Employees have the right to request it, and it's a lot more important than employers regularly realize, because it does directly impact often an employee's ability to be able to get another role. It's also one of the most kind of frequent flashpoints because employees ask for it, employers either delay or don't issue it, or they try to quote unquote send a message by not issuing it, or they put things in there that they really should not be putting in there, and they oftentimes can't open themselves to liability, and that's the employer opening up themselves to liability. I'll get into that, but really, the only thing that you have to put into the experience certificate is very simply the fact that that person was employed by your company. The employment dates. So John Doe was employed from September to blah blah of those years. So just confirming that, confirming the job title and the role, and the salary that the employee was being paid. So very, very factual, very, very basic.
Okay.
It is. I think people often confuse it with a recommendation letter. This is not recommending or not recommending someone. It is simply a certificate saying this person was employed by our company from this date to that date. This was their job title. This is how much they were paid. And that's really it. So employees are entitled to it, and it's a very basic certificate that can be issued. I think where employers get it wrong is, again, they either delay or they don't issue it at all, or they get themselves into trouble by starting to put things in there, that the person was terminated for a poor attitude or bad performance. They start putting in things about incompetency, etc., and those can often give rise to defamation claims by the employee against the employer.
Okay.
So it's if there was genuine misconduct, you have other legal routes to take against the employee. The employment certificate is not one of those. It is simply a certificate saying that effectively certifies that this person was employed by your company, and
You were
that's it.
here. These
That's
were the
it.
dates. This is what we paid
Exactly.
you. This is all. Basically, okay.
I mean, it's a little bit like the police clearance letter, right? It simply says we don't have a record of there being any misconduct by this person. It's not saying you're a terrific person and or you're not. It's simply stating a matter of fact.
Okay. And an experience certificate is with notice or without notice.
Correct. Yeah.
It applies to both situations. Okay. Let's talk about the really juicy stuff, Raymond. What kind of common mistakes do employers make when they terminate people? That aside from this experience certificate and saying, he was just lousy or whatever.
Yeah.
What could lead to legal trouble? What kinds of things do people do?
Yeah. So I mean, it's kind of interesting how consistent the patterns are. It's usually there's the wrong notice period is given. Right. Especially confusing probation rules with standard termination rules, or just not following what is actually written in the contract in terms of that notice period. Second one is no written notice or a sloppy notice being given in terms of you either do everything verbally or you do issue something in writing, but it's vague in terms of when the termination decision was taken, when the last day is, etc. The other one, and I kind of alluded to it earlier, is trying to terminate under the without notice provision when it clearly should have fallen into a regular termination with notice.
Okay.
And if you are terminating without notice, not having any sort of evidence file, any investigation file that's been conducted before that termination decision has been done. And then the other one is sort of your usual, where it's either late or incomplete or non-existent final settlement of payment to the employee.
Yeah.
So I mean those are usually the ones that often lead to legal trouble. I mean, in short, it's really the legal trouble comes less from the decision to terminate than it is to how you execute it.
Yeah,
Think of it as a process rather than an event.
Yeah. And if you want to get rid of somebody, just get it done. Get rid of them.
Yeah, I mean,
if you take that point of
well,
view.
I mean, again, like even if you're terminating somebody during their even if they've passed probation, right? And so let's say they have a 2 month or a 3 month notice period. There's nothing requiring you, because you can't put it in the contract that the employer has the right to effectively pay you in lieu, right? So you can say, I'm giving you this notice. I'm paying you for these 2 months. Don't come back.
Yeah, okay. Which is, I guess, a lot of people are
I
quite happy
mean,
with that.
right. So that would, I mean, yes, you have to pay somebody for 2 months, let's say, for not working. But, if you really don't like the sight of this person, you don't have to see them again. And that employee goes off for 2 months and, effectively is paid and gets to look for another job. So there's a much easier way of doing it than trying to make things difficult for everybody involved.
That's for sure. All right then. So if an employee, if you think, hold on a minute, this was not fair, this wasn't handled properly, what do I need to do if I were to file a complaint? Where do I go? How does that start?
Yeah, it's a little bit similar to any of these things where you start smelling like there's a dispute that's going to happen.
It's
I
kind of a
think,
feeling.
yeah, you sort of begin to understand it. I would say, first and foremost, keep as much of it as you can in writing. I would first request key documents. If you haven't already received one, request a termination letter or a termination notice,
Right.
because you want that in writing. Request a final settlement breakdown. Get it in writing as to when your last working day is, and request an experience certificate if you want one. So, I mean, make those requests and make them in writing if you haven't received any of those yet. I would begin to preserve evidence. Key documents such as your employment contract, your offer letter, any HR emails that have been sent to you around your performance review, any warnings if you've received any attendance records, for example, if that's relevant. So any of those kind of messages around the termination, around things that highlight that, I would make sure that you preserve them and save them somewhere safe.
Right.
And again, try to put as much of it in writing as you can. Try to get a written resolution in writing. And if that still doesn't get resolved, or you're not hearing anything, or things aren't playing out as they should be, you have a right to file an initial complaint with the Ministry of Human Resources. And that's usually the front door for any private sector employment disputes.
Right.
There you can have a mediated settlement between the employee and the employer. I have been to some of these. I would say emotions tend to run very high on both sides. So again, trying to keep your cool as both employer or employee, trying to keep your wits about you in terms of being factual about dates, documents, process. And that, if all else fails, obviously come see your favorite lawyer.
Your friendly neighborhood lawyer. That's interesting. The advice, that's really good advice. Trying to be calm is so useful in cases like this. It's so often overlooked, I think. So two things here, and I'll ask you from both perspectives in an effort to be balanced. The practical advice you would give employers to make sure they're compliant with the law when ending contracts, and by the same token, practical advice for employees as well.
Yeah. For employers, I think it's really just having kind of, again, having an internal guideline, an internal compliance playbook about how you do these things. Choose the correct legal pathway. Make sure that your contracts are clear and accurate about probation periods, probation termination, your standard termination. Even if you haven't experienced it before, create an internal playbook about what you would do if something arose to the need to conduct an internal investigation where it might lead to a termination without notice. So create that in advance, so you're not sort of playing retrospective, right?
Yeah.
Put things in writing internally for your HR if you don't have one, or if you yourself are the HR. Create that system, create it in writing. Put as much of these things in writing as you can in terms of proper emails, proper letters with dates, last working day. State things clearly and professionally. And if you are in a very rare situation, again, claiming that there's misconduct, before you send that issue out, build a file, have the investigation conducted, create evidence, and have that written decision all encapsulated before you make the decision.
Okay. Ducks in a row.
Yeah, exactly.
Yeah.
And really a lot of it is the finances. Make sure that your finance loop is closed quickly and early. Make sure that you have that final settlement there. Make sure it's clear. Have a settlement breakdown provided to the employee. Make sure that you're both kind of in agreement as to what's owed, what's been paid, et cetera. So, because that's usually the majority of the problem. And if you're in a slightly larger organization, make sure that you've trained your managers and your middle management in terms of how to deal with these things and have a system in place. That's really the best course of action. I think in terms of employees, I would say, a lot of people are often very excited once they get the job offer. Make sure that you read the offer letter. Make sure that you read the contract, not just kind of skimming it through and just seeing how much you're going to be paid and signing off.
You see, that seems like
it's the fine
obvious
print,
thing,
right?
But the fine print is so. At least read your contract.
I mean, these aren't, unless you're, the CEO of a blue chip company. These contracts are not, overly complicated or massive.
Yeah.
Do give it a proper read. Make sure that you understand what your probation is, what your notice period is. How do you have to serve notice? How do they have to serve notice? Whether your employer can place you on gardening leave or not, what options they have available to them in case they do decide to terminate you. How are your final pay and your benefits going to be handled? So just kind of understanding that before you go into it, and if there's any ambiguity, making sure that you clarify that before you sign on the dotted line and you start. Why does this all matter? Many disputes come down to what notice applied, when was my last day, and how much should I have been paid. So if you have a clear understanding about those three, then you've already done a really good job.
Pretty much covers it, I think. Have we missed anything? I think so. Mostly, yeah. Okay. I was going to ask you: is there any one thing in a contract that you should look out for, or is there? I don't know. Is there anything that always that you see that jumps out in contracts where you think, I wish you wouldn't phrase it that way, or I don't know. I don't want to miss anything here.
Yeah, it's always kind of hard to say, if there was that one thing, because I think they all sort of. It's like a good mosaic, right? It all has to fit in together. It's like a nice puzzle. Even if you have a really great puzzle piece, if you've got one thing missing, it doesn't quite look right. So just make sure that everything is there. Make sure there isn't any ambiguity. If you don't understand something, make sure that you ask either the company or a good lawyer. So yeah, just understand the basics, not just how much you're going to be paid and how much annual leave you're going to have.
Okay.
I would say, and from the employer side is, just make sure that you're always on top of the legal developments that are occurring, and just because that employment contract has been in your drawer for the past 10 years doesn't mean that it's still working. It's always nice to have it checked out, just like a physical check that you would have with your doctor once a year. Kind of get it checked out and make sure that you're on top of it.
Well, that's really good advice, because one thing that we do know here, particularly since COVID, and we talked about this a number of times, is the speed at which amendments to the law
Yeah.
are happening and continue to happen.
And you know my genuine dislike of the word boilerplate.
I
Yeah,
do. I've
yeah.
noticed that. Yeah.
Yeah. So I mean, look, just like any good doctor would advise you to get an annual checkup, so you see a problem before it arises.
Yep.
Kind of have a nice little legal check for your company. Doesn't have to be once a year, but do that often for things, especially things like AML, KYC, employment, insurance. Just make sure that you've got that right, because the law is changing very, very rapidly here, especially.
Yeah.
And you as a business owner already have a lot of things on your mind. The last thing that you've got on your mind is what contract an employee signed 5 years ago.
Fair enough. Ignorance is no excuse as well, I guess. So this is now going to be a podcast in and of itself.
Absolutely.
It's spun off completely, so look out for it online. But for now, Raymond Kisswany, partner at Davidson and Co. Appreciate you coming in. Thank you.
Thank you very much.
It's good to see
you
you.
next week.
This is Mirror Business FM. It's the morning drive. Get in touch. Tell us what you think on social media. Like, subscribe. We appreciate that greatly. And remember, we're on YouTube if you want to listen and or watch again. Number of different channels as well across social media. And wherever you get your podcast, just look for Mirror Business FM.